Today we're with David Shapiro. David Shapiro is a criminal lawyer in San Diego, California. Today he's agreed to answer some questions related to DUI. If you've got a DUI in San Diego, obviously you can give David a call. Some of these questions are, although specific to individuals, pretty applicable to most people. So if you're going through the DUI process, some of these things you may find very beneficial. Also, in addition to that, David's agreed to answer any direct questions you have just simply on the by making a comment section on the video below. So if you're going through the process, have a question, just shoot over the question to him, and he'll try to get back with you with an answer. With that said, David, let's go to our first question that was asked, and this one's directly towards you. How much do you charge to defend a DUI?
How much do I charge to defend a DUI? It depends. Generally speaking, first-time DUI is usually anywhere from, let's say, $2,500 and up. It depends what's included, what's not included. It will depend where the case is, meaning whether it's within San Diego County and also within the branch courthouses. If it's out of San Diego County, what type of a case it is, if it's a prior DUI involved within 10 years, if the person's in custody, if they're out of custody, if it involves injury, if it's a felony DUI, whether it involves injury or prior DUIs that get it to be a felony. It all depends. Generally speaking, at least $2,500 and up. That usually will include the DMV administrative hearing process, would not include trial, that $2,500 number. But, the good thing is that I own my own firm. I have that flexibility to work on fees and sometimes take chances on people that I really believe, whether or not I believe in their case or whether or not I really believe in them, and can work with you as best as possible.
Okay. Next question we had was, how long does the entire DUI trial process take?
The trial process, a DUI trial itself, could take anywhere from 2 days to weeks, depending on how complicated it is. But as far as the overall process, how it works, particularly at least here in San Diego, and generally speaking throughout California, is this: if you get arrested today, you will have 10 calendar days, not court days, calendar days, from your arrest to set up your DMV administrative hearing. That's the first step usually. In fact, unless you're actually in custody, so assuming you don't bail out, if you don't bail out, you'll have court. But if you bail out, the first real step would be the administrative hearing process. The hearing itself is not within 10 calendar days of your arrest, but the request needs to be made within 10 calendar days of the arrest, and then that hearing will be, anywhere from 30 to 60 days out. As far as the first court date, usually it could be a couple of weeks, it could be a month, I've seen it as far as 2 months out, assuming you bail out of custody. So, at least a couple of months, and it all depends. There's some strategy behind resolving cases early that probably should resolve early. There's some strategy behind dragging cases out if that's in the best interest of the client. So I've handled DUI cases that have resolved within a couple of days. I've handled DUI cases that have taken a year and a half to resolve, whether it goes to trial or not. It ultimately depends what's in the best interest of the client, and if the client's committed to their defense and has the resources and the abilities to basically come along with the ride with me and understand the reasons why we're doing things. And I always let my clients know the reason why we're continuing the case, or the reason why I think we should resolve it sooner, so they know exactly and can feel comfortable in their decision.
Okay, makes sense. Next question we have, and this one's again fairly frequent, and I hear it a lot. Is it true that you should never blow on a DUI?
Okay, so we were talking about the breathalyzer test here. If you're not on DUI probation, if you're not on DUI probation, you are not required to take the handheld breathalyzer, which is known as the preliminary alcohol screening device, or the PAS test. So let's assume, for argument's sake, you are not on DUI probation. You get pulled over for whatever reason. You go through a checkpoint, whatever the case may be. You hand the officer your license and your registration, and you keep your mouth closed. You don't answer where you're coming from. You don't answer where you're going. You certainly don't answer what you had to drink. You don't say, I had 2 beers 6 hours ago. A lot of times that actually hurts your case because it shows, based on those statements, that your blood alcohol level is coming down. which means you were probably higher at the time driving. California's an at that time driving state for purposes of being under the influence and your blood alcohol level. You don't do a field sobriety test. The field sobriety test you certainly don't do would be the handheld breathalyzer. Now that all changes in the event you actually do get arrested. But if you don't do all that stuff, the argument is, well, how'd you get arrested? Why'd you get arrested? Because the officer would not have enough what he or she needs under the law to arrest you if you just keep your mouth closed, if you don't admit you were driving, if you don't admit you were drinking. I mean, I say don't admit you were driving. Sometimes you'd be surprised. You know, you could be on the side of the road, you and I could be on the side of the road, and they need to prove that you were driving the car. So why even give them that? Why give them a field sobriety test that they can infer, whether right or wrong, that that's indicative of someone who's under the influence? Why give them a blood alcohol level, albeit not as scientifically reliable as a breath or a blood test after you're arrested, but why give them that handheld breathalyzer when it's a voluntary test? Now, 95 out of 96 people that come to my office on DUIs, have done all that. The reality is, if they knew that then, they probably wouldn't be in this position. But you definitely do not have to take the handheld breathalyzer unless you're on DUI probation, then that's a condition of your probation. Now, if you get arrested for whatever reason, then the issue is California then turns into what's known as an implied consent state, which means you would have to, in order to avoid being charged with the refusal allegation, have to submit to blood or breath. If you say no, in all likelihood, law enforcement can get a warrant, and they can get it that way, through a forced blood draw. But certainly on the front end, before you're arrested, you should do as little as possible to give law enforcement the evidence they need to arrest you, and ideally, don't give them enough evidence to convict you. Not saying lie, I'm not saying underestimate, politely decline to answer any questions other than provide your license or registration.
Okay, and let me follow up with that on that question for you, though. If so, you're saying when the officer pulls you over, obviously you said hand him your license and registration, but if he asks you where you've been or whatever, what's your response supposed to be in that scenario?
It's my understanding that I do not have to answer any questions without my attorney present. It's fine.
Okay.
Or you could not answering anything, officer, with all due respect. Don't be let me use an internet appropriate word here. You don't have to be an idiot about it. You don't have to be disrespectful about it. But you don't have to give them anything. The reason why they ask you those questions, everything they ask you, if the officer knows what they're doing, is calculated. They're trying to find out how long you've been driving. They're trying to find out your drinking pattern to establish or eliminate possible defenses that you might have. So if you say something like, my last drink was 4 hours ago, whether that's true or not, what you've just done is eliminated what's known as a rising blood alcohol defense based on your own statements. If you keep quiet, it's up to the district attorney or the city attorney, depending where the case is, to basically rule that out as a reasonable interpretation of the evidence. And that's how you win, even if everything else lines up. That's how you win 0.10, 0.11 cases of trial. That's how I have won them in the past, where the client did not establish a drinking pattern, where they're going, where they're coming from, what did they have to eat, what did they have to drink, how much sleep did they have. All those factors go into possibly your level of intoxication and how your body processes the alcohol. So let them speculate to it, because the more they need to speculate, the more difficult it is for them to get the conviction.
Makes total sense. Okay. This question is directly for you as well. What is your success ratio on DUIs?
Well, that's something I get a lot. I mean, I actually get that from in-laws and friends of friends sometimes to come up to me and say, well, what's your win percentage? And, it all depends. Usually what I say is, well, what's a win? Sometimes a win may be getting the minimum for the charge that you're convicted of. Sometimes a win may be resolving it for a lesser included offense. Sometimes a win may be what people may think is a win on TV, where you go to trial on 6 counts and you beat all 6 counts. Sometimes a win is where you beat the offer. The city attorney or the prosecutor wants your client to do X number of conditions as a sentence. You go to trial, and even if you get convicted, you beat their offer. You wind up in a better position. So, I never give percentages, and any attorney who does, boasting about the highest success rate and all that nonsense. First of all, it's borderline unethical because they have nothing to verify it, unless they do, and if they do, that's news to me. And the second is, what's successful? What I may view as successful, it doesn't really matter. It matters what my client views as successful. So, I may say, wow, we beat the offer. That's as good as we could have done with the facts. The client may say, well, okay, that really wasn't that great. Or vice versa, for that matter. They may be thrilled with the outcome, and they may view it as their case is success. But I may hope that we could have taken it a different direction or maybe fought on a little bit longer. But the client may want to cut their losses. So it's all relative. More importantly, what the client thinks is a success. So, or what the client thinks is a success is the more important issue.
Okay, makes sense. And the final question is if I get convicted of a DUI, will that be on my record forever?
Actually, one thing going back to the last question too, something I think people need to be wary of is when attorneys talk about they have 100% dismissal rate or 100% acquittal rate and all that stuff. That's one of two things: either they're full of what, or they haven't done a lot of cases. A lot of people say, I never lost a DUI trial. Well, you never tried a DUI trial, then probably.
Right. That makes sense.
I get every DUI I handled dismissed. What you do? You did 1, you did 2,
right.
You did 5. You know what I'm saying? You need to do hundreds upon hundreds in this county like myself and a lot of other good attorneys have. So going to the fifth question, my apologies, with respect to the DUI being on your record forever. Not necessarily. For TV purposes, it would generally be there for a couple of years. You get problems in California being a negligent operator, basically a bad driver. You have 4 points in a year, 6 points in 2 years, 8 points in 3 years. You get 2 points if you're convicted of a DUI, and a lot of DUI lesser-related offenses. As far as it being on your record, DUIs are priorable in California for a period of 10 years. After 10 years, it doesn't mean that DUI is no longer, quote-unquote, on your record. It just means it cannot be used as an enhancement, at least on paper, and treated as a second or a third or a multiple DUI. A lot of times people think that also that when the case is done with, they automatically get what's known as an expungement, or what's misreferred to or inappropriately referred to as an expungement under 1203.4 of the Penal Code. A couple things need to take place. The first is you need to successfully complete probation, and then you could apply for relief under 1203.4 of the Penal Code, which a lot of people refer to as expungement. Assuming that's granted, the conviction gets set aside and the case is dismissed. However, the DA or the prosecutor could still use that conviction for priorability purposes if it's within that 10-year period. DMV still knows about it, your insurance still knows about it, but for most general background checks, you could avoid saying you were convicted of a DUI or a misdemeanor. Okay, but what's important to know, what a lot of attorneys, even good attorneys, probably don't know, is that whereas 95% of misdemeanors, if you successfully complete probation, you're automatically entitled to this 1203.4 expungement or dismissal relief. DUI statutes, it's not an automatic right that you have. You have to make a showing, or basically implore the court to make a finding that doing so would be in the interest of justice. So you have to usually put, or what you should be doing, is putting together a packet of information to give the judge the information that he or she needs in order to feel comfortable in giving you the relief that you're not automatically entitled to. So it may be on your DMV record for a period of time. It may seem like forever for insurance purposes. It may seem like forever with this 10-year window. But if you get it expunged, that's the best you can hope for a lot of times if you're convicted. And just let it lapse after those 10 years. It's not to say it won't come up in the future, but it won't be used for priorability purposes.
Okay. All right. Well, David, I want to thank you for your time. For the people watching, obviously, if you've been charged with the DUI, feel free to reach out to David. His contact information is below in the description. Also, like I said before, if you have any questions, feel free to put the comments below in the video, and David will get back to you as soon as he can. With that said, David, thank you for your time.
My pleasure. Thank you.